Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Yesterday, we discussed the Bilkis Bano case and I just cautioned you that it may have political overtones. And as expected by me, lot of controversies are going on when we see the news clippings and the TV channels also, right? Another issue has come up like this, where a session judge was being commented upon for his observation regarding the sexually provocating dressing of a woman. Of course, I am of the view that the Honorable Kerala High Court may take up the matter sumoto and clear the air. Before that, let us discuss as to what happened. Please remember that this order was given in connection with the granting of anticipatory bail filed by Civic Chandran, his alias name. Original name is Civic Chandran. So alias CV Kuttan. His original name is CV Kuttan. Okay, versus state of this Kerala. Right. So he filed a petition under section 438 CRPC, that is anticipatory bail, in crime number 501 by 2022, registered under sections 354, 354A, 341 and 341 IPC of Koyal Pandi PS of Kozhikode district. Right. On 12th of this month, on 12/8/2022, the principal decision judge, Mr. S. Krishna Kumar of Kozhikode, and he, while giving bail in this miscellaneous petition, that is CRLP number 1303 by 2022, he commented on the provocative dress of the complainant. Why he commented? This is another problem, but anyway, why things led to that controversy, let us examine. So it is better to know the brief details of the case, right? This Civic Chandran is a well-known poet and is a physically disabled person and an old man, senior citizen, aged about 74 years. So the victim is aged about 30 years, right? So the prosecution case says that on 8/2/2000, not now, about 2 years back, 8/2/2000 at about 5 p.m., right? Actually, on that day, the accused conducted a camp for the lady poets, and after the function is over, when all of them were returning, the accused actually caught hold of the complainant or caught hands of the complainant and forcibly took her to a lone place. Right? And he asked the complainant to lie on his lap. He pressed her breast and actually thus tried to outrace her modesty. This happened on 8/2/2000 and she has reported the matter to that Koyal Pandi PS on 29/7/2002. 29/7/2000. So this almost 5 months later only she reported the matter. That means inordinate delay in reporting the FIR, right? And as regards her educational background, she is a highly educated woman and she is a posh lady, and it is not known as to why she delayed in reporting the matter, and the explanation is not properly given or no proper explanation is forthcoming, right? As regards this Civic Chandran, is a man already told you, aged about 74 years. His eldest daughter is working as deputy collector. Second one is an engineer. So high-fi family, right? But incident is there. They have registered the case. They can't help. So therefore, he approached the court for bail. Normally, the advocate on behalf of Mr. Chandran, he has produced some photos of the complainant while attending the so-called function. Her dress, as per the opinion of the judge, it is sexually provocating. Another point raised by the appellant is that she came there along with her boyfriend Rahul also. They spent time there also, right? So it is only a false allegation, or in order to take vengeance against him, she filed this false case. This is the version of the so-called appellant. Now, the judge, session judge, looked into the section 354A. So please remember, 350 for proving 354A, number one, there should be physical contact. There should be advancements. There should be colorful or sexually colored remarks, or there should be unnecessary demand for sexual intercourse. So all these things are, if they are proved or if they are available, yes, definitely you can make out a case under section 354 and 354A also. But nothing of the sort is there, right? While discussing these points, legal points, the so-called Justice Judge Mr. Krishna Kumar, he stated that the photos revealed that the complainant is exposing sexually provocative dress. And he also opined that it is impossible for a man of 74 years to 74 years and a physically disabled person, he can forcibly put her on his lap. But the FIR says he asked her to lie on his lap. Here, the judge observes that he can forcibly put her in his lap. So, please remember, this is highly improbable, and the dress worn by the complainant is sexually provocative. So, this is, in my view, unnecessary remark on the part of the judge. But whatever this is, now, lot of petitions are pouring in to the Honorable High Court of Kerala, and one C. Shukur, so he filed he sent an email to the High Court complaining against the judge, requesting to take disciplinary action as the order is an onslaught on the protection of women. But I am sure no disciplinary action can be taken against the judge for an erroneous order, that too given in the capacity of the presiding officer of a court. Only the court is left for you is go for appeal, go for revision, that's all. Only to challenge in higher court, that's all. Now, since a lot of complaints are pouring in, the Kerala High Court may take up the matter suo moto. So there is no necessity for the government to file a revision. There is no necessity for the prosecution to come up to the High Court without waiting for the prosecution or the complainant. Definitely, basing on the public outrage, they may take up the matter. So, because as per the opinion of the general people, the remarks are uncharitable observations by the judge, on the part of the judge. So, it has become a controversial issue. So, yesterday I told you in the Bilkis Bano case also, I told you that may become controversial. It is definitely, so many people are commenting on the, of course, no doubt, he can give bail. After all, whatever we say, bail is the personal discretion of the judge. So at this stage, I am inclined to give bail. Yes, nobody can opt. So here also is given anticipated bail to him on 50,000 on production of 2 surety is quite common. But the writing of the observation, like the provocative sexual dressing of the complainant is not acceptable. So this is the word. Of course, second, where is the guarantee that a person of 74 years cannot conduct the outrage of modest woman? Very recently I told you that Bangalore case, kidnapping or honey trapping case, yes, there were when around 11:30 p.m. when the woman called that fellow, aged about 73 years, he came driving the vehicle alone. What for? For having the sexual pleasure, is it not? After all, 1 year is only. No doubt, he may be a physically challenged person. Do you think that physically challenged persons are all very physical incapacity? May be there, but they will definitely whatever it is, whether he has done wrong thing or not, investigation only can decide. But as far as judgment, the observation is concerned, the judge, if he had given bail in simple terms, it's okay. But since he commented or since he made uncharitable observation on the dressing of the woman, it has become a controversial issue. So friends, if at all any students aspiring for judges see this video, please be careful while drafting the bail order also. Okay, thank you very much.